Morning, everyone. I'm going to be speaking about the Uzani case, which I would imagine most people in the audience have already read. In the interest of time, and I was under the impression I had 10 minutes, not 15, Peter, but anyway, I'm not going to be going through the details of the facts and all of the reasoning in the case, but I want to pick out certain aspects that I think may well be of concern to any person who might have made an application under Section 24 capital G in terms of NEMA. So essentially what happened was that, let's call him an environmental crusader, the person who is the, I suppose, the activist behind the Uzani outfit, decided that he would get a list of people who'd made applications in terms of Section 24 capital G to the Gauteng department, and then prosecute them in terms of Section 24 capital F, alternatively the equivalent provisions under the Environment Conservation Act. This particular case, the offender was BP, and there were a number of activities. These were establishment of petrol stations where BP had not complied with the requirements. It being common cause that the activities in question were identified activities in terms of either the Environment Conservation Act or of NEMA. And I think this case raises the spectre of lists of 24G applications being picked up by people who want to pursue private prosecutions, and these applicants who thought they were probably free of any criminal consequences now being subject to private prosecutions in terms of the Act. And certainly if the decisions follow the decision in Uzani, it's almost for the private prosecutor like shooting fish in a barrel. I think though that there are a number of problems with the decision that I'm going to identify, and what I'm going to pick up on today, not necessarily all the problems in the decision, that I think if these were dealt with properly, it wouldn't be such an easy prospect for environmental crusaders to take this route. Just in general, I think that the decision in Uzani was correct by and large in relation to the principles connected to private prosecutions. In other words, the requirements that would have to be met by somebody who wants to bring a private prosecution in terms of Section 33 of NEMA. I think the court was correct in interpreting those in the way that it did, without going into any more detail today. But in relation to the application, there's one aspect that I want to pick up on, and then the other aspects that I want to speak about are in relation to the actual conviction. One of the requirements of Section 33 is that the person bringing the private prosecution needs to do so in the public interest or interest of the environment. I'm not going to talk at all about the apparently mercenary objectives of Uzani in this case. That's another story for another day. And I don't think that mercenary objectives, as the court indicated, necessarily undermine the existence of public interest or interest of the environment. But in this case, bearing in mind that what we're dealing with is a situation where the person being prosecuted, BP, has already gone through a Section 24G application procedure, and one assumes that that procedure ran to its conclusion. In other words, that the authority either authorized the activity or required certain conditions maybe to be met prior to that activity being authorized. So in other words, the actual threat of environmental harm from a physical point of view would have been addressed by the Section 24 capital G process. And yet the court relies on the evidence of an expert, Professor van der Walt, and it says somewhat cryptically in paragraph 101, the failure to upfront produce, and I'm quoting here verbatim, the failure to upfront produce an EIA report, while the failure of any applications for authorization under Section 24G to provide rectification reports demonstrates that the prosecution is in the interest of the protection of the environment. I'm not exactly sure what that means. Maybe someone else can help me during discussion. But I would have thought that the actual damage to the environment has already been addressed by the Section 24 capital G process. It's not to say that a prosecution would not be in the public interest or interest of the environment, but that interest would be more along the lines of providing some kind of deterrence. So either general or personal deterrence in relation to repeated offences or offences carried out by other parties. The impact on the environment, as far as I understand, if one has gone through a Section 24G process, has already been addressed. Then in relation to the conviction, essentially what the court did was it said that in terms of Section 24G application, essentially what the applicant is doing is it's saying that it has committed an offence in terms of Section 24F. Therefore, it's committed an offence in terms of Section 24F, therefore it is guilty. Now, the problem with that, well, the first problem that I've picked up is that in paragraph 76 of the judgment, BP raised a preliminary issue regarding whether the offence is a strict liability offence or whether mens rea is required. And the court didn't deal with that issue again in the judgment. So when it came to the actual conviction, didn't consider the issue of mens rea at all. Now, in relation to strict liability, and remember here we're dealing with a statutory offence, in 1967, in the AD case of S versus Orenstein, which was quoted with approval in the Constitutional Court in the landmark case of S versus Coetzee in 1997, the court said, in the absence of clear and convincing indications to the contrary in the enactment, it's presumed to have intended that violations, this is the legislature is presumed to have intended, that violations of statutory prohibitions would not be punishable in the absence of mens rea in some degree or other. Now, Section 24F does not mention fault. It mentions neither intention nor negligence. So there's no mention at all of any mens rea requirement. Now, usually when the legislature wants to provide for a strict criminal liability offence, it does so by means of what we call a reverse onus provision. Or there's some language in the provision that suggests strict liability. Here, mens rea is not mentioned at all. So there's silence in regard to mens rea. So the presumption is not a presumption in favor of strict liability, but a presumption in favor of some kind of fault. And certainly in relation to Section 24F offences, I would argue that fault is an important element of these offences. Why is that? Firstly, there's the difficulty of establishing whether an activity is an identified activity or not. Not in all cases, but in certain cases. And that's illustrated, for example, in the silver mine case, where there was no certainty as to whether that activity was identified or not, despite having received senior counsel opinion and unsure advice from the authority in question. Secondly, there's the real possibility of the authority asserting that the activity is an identified one when it is not. And by way of example, I'll mention the infamous 500-meter rule in relation to water uses that many people will be familiar with. And then thirdly, there are cases that are on record where the offender apparently has not had fault. Now, the first observation is that in some of these cases, we may have been dealing with what the Americans call willful blindness. And that's obviously an avenue that we can pursue in more detail, again, at another stage. But certainly on the stated facts in reported cases, in both the Supersize and Michalisburg cases, it appeared as if the developer did not have mens rea in relation to committing the Section 24F case. In the Supersize case, the developer thought that it had an authorization, whereas the authorization had been fraudulently drafted by an agent, let's call him that. And in the Michalisburg case, the court didn't really challenge this, but in the Michalisburg case, the developer said that the local authority had told him he didn't need authorization and therefore he didn't know he needed it. So in both of those cases, I think there are questions that might arise in relation to whether those were genuine situations or not. But as they stated in those judgments, those would be cases where mens rea is not present. So my argument would be that mens rea is a requirement of Section 24 capital F. And this would be something that would have to be canvassed in any cases involving prosecutions in terms of Section 24 capital F, whether those are prosecutions by the NPA or private prosecutions. Just another quick word about strict liability, and that is that in the overwhelming majority of cases involving strict liability or provisions where there clearly is some attempt at providing strict criminal liability, those have almost universally been held to be unconstitutional because of various infringements of the due process rights in the Constitution. Final observation about the judgment that I want to make is that essentially what we have here is a situation where BP in this case has incriminated itself by virtue of making those Section 24 capital G applications. So there's a situation here where there's self-incrimination, which is also something that is frowned upon by the Constitution. Now, there may well be certain situations where self-incrimination may be acceptable, but in this case, it's not necessary anyway, because it's not as if the only way that the information can be gleaned that a Section 24F offence has been committed is through the Section 24 capital G process. When one simply has to ask the question, has this developer got an environmental authorization? If the answer is no, then the offence, or certainly the actus reus, would seem to have been committed. So the self-incrimination is not necessary for proof of the offence, but nevertheless, Section 24G application does amount to self-incrimination, and I think this needs to be looked at, not necessarily in perspective of a future judgment, but certainly in relation to the drafting of Section 24G. In conclusion, I think the Uzani case raises yet more concerns in relation to Section 24 capital G and its links, if you want to call them that, with Section 24 capital F. In my view, yet another compelling reason why we need to reconsider Section 24 capital G and think of redrafting it to focus on its true objective, which in my view is to deal with the environmental impacts of activities that have been carried out without authorization. Its main objective is not, in my view again, to punish somebody who's carried out that activity. If you want to punish people who've carried out identified activities without authorization, we need to go down the route of criminal prosecution. So those are my thoughts, and I'm sure that there would be some observations that people have in relation to Section 24 capital G, those people who've been through the processes. So I look forward to the discussion in due course. Thank you.